Tan versus Lagrama, GR number 15-128, 2002. Facts: Tan, President of the Supreme Theatre Group. Lagrama, painter of movie billboards murals for 10 years. Tan scolded Lagrama for urinating in the workplace and told him to stop working and leave. Lagrama filed a case for illegal dismissal. Was Lagrama an employee or an independent contractor? If employee was illegally dismissed. Argument of the parties: Lagrama paid per mural, no mural, no pay. Salary employer work daily in Tan Theater under Tan's rule and supervision. Tan petitioner, he was not dismissed, he just stopped painting after being reprimanded. He was ordered to leave and not allowed to work anymore, which is illegal dismissal. I worked for others in owners, so not exclusive. Side jobs where only weekends main work was for Tan. The ruling of the Supreme Court, Lagrama was a waiver. Tan had control over his work, base rule of supervision, right to fire. Dismissal was illegal. No just cause and no due process separation period after this final he ought to deserve could be related peace rate or not entitled. Control test is the most important determinant. Even if paid per piece per mural, Lagrama's work was subject to tense control. Regular employee who enjoys security of tenure and cannot be dismissed without valid cause and due process. The doctrine of this determine the employer-employee relationship, selection, payment, wages, or to dismiss. The control the most important. Piece rate payment to setting it the employer's salary. Regular employees cannot be dismissed without just cause and due process. Tan versus Lagrama. The facts of the case was Tan was the owner of a theater. Lagrama was a painter there. Uh, uh, Lagrama peed on the workplace. Then he was reprimanded by Lagrama for urinating in the workplace. And Lagrama said that he was not. Tan says that he shouldn't continue painting anymore. And that constitutes an illegal dismissal. Tan filed a case with the labor arbiter favoring him and for back wages. Hmm. Lagrama appealed and NLR's favoring him that in his contention that Lagrama was an independent contractor. The issue here is whether or not There's an employer relationship between Tan and Lagrama. In this case, there only was uh, oh, the case in the Supreme Court favoring Lagrama, applying the proposed payment selection power to dismiss were all present, and the most important is the control, where Lagrama was the Lagrama was mm, Lagrama was Lagrama Lagrama is being supervised by Tan during his work, and means by giving him all the tools that he needs, and and of course that constitutes the method on how he will work on the painting. And lastly is that yes, the draw for not accepting the paintings. Then the stone draw not accepting the painting. It reinforces playing along to 80%. Granting this additional support for example. The court emphasized that the control of the system was the evidence indicated that the exercise control, including setting rules, work area, and providing stores rules, working area. Then insufficient to justify the dismissal of Lagrama that any work is regulation